On page 247 of the handout, we actually give you the fact pattern for the program, which we're going to be using this afternoon. And it's a fact pattern involving issues such as 240, maybe. Sole proximate cause, maybe. Recalcitrant worker, I'll say the same thing, maybe. But it's a good problem because it's well balanced, and it's actually a case that was right out of the appellate division not too long ago. And it actually has, we find, a balance for both the plaintiff and the defendant's side on the case. So what I'm going to do is I'm going to give you opening statements in the case so that you are familiar with the case. I know many of you didn't have an opportunity to read it beforehand. I'll give you opening statements both ways, for the plaintiff and for the defense. But since I have a little bit of time, I want to tell you what I'm going to try and do during the opening statement. One of the things that becomes important when lawyers deliver opening statements is to really say it like you mean it. Say it with some righteous indignation, with some fervor, so that we're up there saying something that could convince the jurors that our side is right. And I see lawyers too often doing things where they don't take advantage of the tools that they have when it comes to speaking. And one of the most important tools that we have when we speak is our voice, and the way that we speak, and the way that we make eye contact with the jurors. And I've seen lawyers hold up notes in front of them, or look down at notes, and they're burying their head in their notes. They don't know if the jurors have a quizzical look on their face, if they're confused. Henry Miller, who I lecture with often, some of you might know him, I love this guy. He actually uses this example, I've stolen it. He says, imagine taking notes and looking at it. And, ladies and gentlemen, there's one other thing I want to tell you. My client, oh yeah, he's innocent. Come on, you can't do it that way. You got to know what your case is all about. And if you do know what your case is all about, say it with some fervor, with some righteous indignation, with some conviction, so that you know you're going to win this case. So let me give you the opening statements in this. It's a labor law case. You'll see exactly what the facts are, and you'll understand what happened. Plaintiff's lawyer. May it please the court, counsel, ladies and gentlemen. This is a case about an accident that should not have happened. It's a case about an accident that did not have to happen, and it's a case about an accident that never, ever should have taken place. But it did take place because of one reason, and only one reason. And the reason that it took place is because of fault. Because the general contractor of a construction site, of a large construction site, and the owner of this same construction site didn't do the one thing that they were required to do. They didn't do the one thing that they were obliged to do, the one thing that they were mandated by law to do, and that one thing was to provide the workers at that construction site with a safe place to work. They didn't provide for safety, and if they had provided for that safety, we wouldn't be here right now. But the owner of this construction site, a company called Midtown Properties, they own many properties throughout Manhattan and the tri-state area, and the construction general contractor, a company by the name of Abraham Construction, they too didn't provide for that safety, for that safe place to work. And as a result of that, a man was injured. And when I say injured, I mean point blank. He was injured, and we say he was injured severely, and we will prove that to you. Well, the man that was injured happens to be my client, Ted Stryker. He's the man seated back here in the back of this courtroom. Ted Stryker was 46 years old at the time of this accident. He was injured, and he was injured so severely that his life has been changed. And I say this to you, his life will never, ever be the same. So let me take you back in time to tell you what was going on. There was a project going up, a construction project, a skyscraper going up in Midtown Manhattan. We're not talking about a small building. We're talking about a 50-story construction project going up, a skyscraper in Midtown Manhattan, a commercial project that was being worked on. The owners knew the one thing they're supposed to provide is safety. The general contractor knew exactly the same thing. They are supposed to provide a safe place to work, and they didn't. And here's why we say this. Ted Stryker, my client, was working for a company called Zucker Construction. His job was to frame windows. Now, when I say frame windows, I'm not talking about framing windows like we have in our kitchen or in our living room, where you can just walk up to the window and start working on the frames. No, we're talking about windows that were 14 to 18 feet up, where they had to use ladders, where they had to use scaffolds, where they had to use construction equipment to actually perform the job duties and to do them well. And what he was doing was, he was working to help out and doing exactly what he was told to do by his company, and of course by the general contractor that was there. Well, the accident dates back to April of 2009, April 26, 2009. And when he arrived at the site, he was instructed to do certain work. What had taken place before this, though, is that there were a number of other workers who were working on a window that was 14 to 18 feet up. And these workers had set up what they want to call a scaffold. I'm telling you, it was a so-called scaffold. It was a makeshift scaffold, and here's what it was. And this becomes crucial. You need to understand this to understand the case. There is a passageway, a doorway, and the doors are basically double doors, very much like the doors in the back of this courtroom. And they open up. But they're not doors that are fixed. They're makeshift doors as well. They're made out of plywood, so that each portion of the door that swings open is 12 feet high and about 4 feet wide. Plywood, that's all they are. And the doors swing out like this. Well, on top of that 12-foot high door on both sides, there was a plank put across it, and there was another plank put across it. And that is what they're considering to be a scaffold. Well, to hold that in place, you're not going to believe this, but this is what they did. They didn't use one bolt. They didn't use a screw. They didn't use a tie down, an outrigger. What they used was they put cinder blocks on top of these boards that were placed across the door. So you have a door that can swing, you have boards on top of it, and on top of the boards you have cinder blocks. I will tell you right now that violates every safety code in existence, not just in New York, but in the federal standards of OSHA as well.
Objection.
The proof will show, ladies and gentlemen, the bottom line is they didn't provide a safe place to work. The judge will instruct you at the end, so if I overstated that, I apologize to my adversary. Ladies and gentlemen, here's what takes place. A man is walking through the construction site. He is directed by his supervisor to carry some wood from one side of the floor to the other side of the floor. And to do this, he's going to have to pass right through that passageway, right where that door was. Understand, there's nothing securing the door to keep it from moving back and forth this way. It's plywood. Nothing to hold it down, no ties, nothing like that at all. So what he does is, he's directed by his supervisor, by his boss, take the wood and bring it to the other side. Ted Stryker doesn't have the ability to say, you know what, boss, I'd rather not do that. I'd rather not do this specific job duty. If he does that, you know what's going to happen. He's not going to have a job anymore. So of course, what he does is he does exactly what he's told, and he starts to carry this wood, and he heads right to that doorway, which they're calling a scaffold. And as he does this, he bumps his shoulder into the door. Well, you could imagine, the best analogy that I can draw is very much like a house of cards. If you hit the bottom card, you know what's going to happen to the entire structure. And that's exactly what's happening here. As he hits the door, of course, the entire thing moves, the doors move, and sure enough, the entire device on top, the boards, the cinder blocks, they topple. And as they fall, the board comes down and hits Ted Stryker squarely in the head. He is rendered unconscious. There is no question about that. There is no question that the board fell from a height. It fell from 12 feet up. It fell from an elevation, no question about that. And in fact, when it hit him on the head and knocked him out, he was out. They had to take him right to the hospital. And when he got to the hospital, the doctors knew immediately, even though he was unconscious at that time, that he had suffered a head injury because just by looking at him, they could see the swelling on his scalp. But the doctors weren't concerned so much about the swelling on his scalp. What concerned the doctors is what was going on underneath the scalp, and actually under the skull, because they wanted to see if there was any brain injury. And they did exactly the right thing. They brought him into the radiology suite, and they did a CAT scan of his skull. And it was there that they determined that he suffered what's known as an acute, large, subdural hematoma. Now, I want to spend some time with you and explain to you exactly what this is. The most important organ in the human body, in our bodies, is the brain. And an extension of the brain is the spinal cord itself. Well, when that board hit Ted in the head, it actually caused damage to the brain. The brain itself is covered by two coverings. Number one, the shell, the outer area that I'm pointing to right now, the skull, the calvarium, the cranium. But underneath that, protecting both the brain and the cord itself, is a protective lining known as the dura. The technical medical term for it is the dura mater. If in fact there is an injury that is severe, and it's severe enough to cause damage to the underside of that dura, the brain will bleed. And there's a problem with this. When the brain controls our body, it controls all neurologic function. That's why I say it's the most important organ in the body, as with the cord. Neurologic function that controls functioning of the muscles, our ability to move, sensory, touch, motor function. All of this is controlled by the brain. Our heart is controlled by the brain. It's a muscle, just like all of the other muscles the brain controls. When that board hit Ted's head, it actually caused a subdural hematoma, a bleed in the brain under the layer of the dura, and it continued to bleed. The problem is this. If I was to suffer an injury, or anyone was, to the leg, as we bleed, the skin would just expand, and there'd be no problem. It would eventually resorb, and it wouldn't be a problem. Not so with the brain, though. When there's a bleed going on under this protective layer, this dura, and the brain bleeds, first it bleeds outward, going towards the skull. But then it can't go any further because it's actually a closed vault. And as the blood hits the cranium, hits the skull, it then pushes back in against the brain. And that's exactly what was happening. And if it continues to press back in against the brain, it's going to cause mass effect. It's actually going to cause a shifting of the brain. It can actually cause death. Well, the doctors recognized this, and luckily for Ted, they recognized it soon, because they knew then they'd have to bring him in for emergency surgery, and they did. And they brought him in for a craniotomy, where they actually knew they were going to have to relieve the pressure from this bleed going on internally in the brain. And they actually shaved his head, they cut through the scalp, made actual burr hole incisions by drills right into the cranium, right into the skull, and actually flipped a piece of it back. It's called a skull flap. And they actually saw then and there that there was a large subdural hematoma. No one in this case will disagree with that. And the doctors evacuated it. And when they evacuated it, it's a fancy medical term, all it means is they remove the blood. The problem is this, though. When you interrupt the electrical functioning of the brain, it can often result in seizures. And the doctors were concerned about seizures. 2 days after the craniotomy, Ted suffered the first of a number of seizures that he would suffer over the course of the years that have come since the accident. The problem is this. Seizures show brain damage. Seizures show unacceptable electrical activity within the brain. Now, I will tell you right now, because of this accident, because of that impact, because of the failure to provide a safe place to work, Ted has not been able to return to his work at Zucker Construction where he worked. He can no longer go back to being a door framer. He did try and get another job as a taxi driver. Unfortunately for him, though, he suffered a seizure while he was driving. And as a result of that, he was unable to continue driving. His license was suspended and then revoked. You can't drive if you suffer seizures. He tried to get a job as a doorman, but because of continual headaches that he's had from the day of the accident right through to today, not one day has gone by where he hasn't suffered from headaches. He has been unable to maintain that job as a doorman. For Ted Stryker, this has been a terrible event. For Ted Stryker and his family, he has a young child, a wife. He's unable to provide for the support that he was able to before the happening of this accident. Ladies and gentlemen, this accident happened because of one reason, and that is fault, the failure to provide a safe place to work by the owner and the general contractor. And I will tell you this, when the law is given to you by the judge at the end of this case, you will see exactly why I say safe place to work means everything in this case. And they failed to provide that safe place to work, and he has been permanently injured. And it's for these reasons that at the close of the evidence in this case, I will stand right here with my partner, Evan Torgan, and he will ask you to award a substantial amount of money to fully and fairly and adequately compensate Ted Stryker and his wife for what has happened, and to award the one thing that you as jurors can do, and that is to award 100% justice. Thank you. Let me go to the defense. Stand over here. May it please the court, counsel, ladies and gentlemen of the jury. This is a case about fault. There is no question that it's a case about fault. But it's a case about fault of one person, and only one person, because one person is solely responsible for the happening of this accident. One person is solely responsible for his own actions. And that one person that is fully and solely and wholly responsible for this and is the cause of his own accident is the plaintiff, Ted Stryker, the man seated right back here. So let me tell you exactly what happened, and let me also take you back in time to tell you what was going on so you fully understand what happened, and so that you get a much broader understanding of exactly what took place in this case. Yes, there was an accident on April 26, 2009, and it was at a Midtown property, a property that was owned by my client, Midtown Properties, and certainly the general contractor, yes, the general contractor, Abraham Contracting, was there as well. We understand that. But you need to know that Zucker Contracting, the employer of the plaintiff, Ted Stryker, was also there. And they had set up a scaffold. When I say they had set up a scaffold, the general contractor didn't set up the scaffold. The owner didn't set up the scaffold. You know who set the scaffold up? The plaintiff's employees, the co-employees of the plaintiff set the scaffold up. And something else happened. This is what took place. And this is why we say the accident was wholly and solely the fault of one person. Ted Stryker is told, take wood from one side of the floor to the other side. He did not have to go through that area. There were other ways to go. This is the way that he chose to go. In fact, when he got to that doorway where the scaffold was set up, there was a co-worker of his, a man that he knew, a man by the name of Roger Murdoch. And he said to Roger, can I come through? And here's what happened. And this is why it's the sole fault of the plaintiff. Roger Murdoch said to him, when he asked if he could come through, he said, hold off, we'll be done in a little while. In effect saying, no, don't come through. That's what he's saying in effect. But there was something else that was going on. It wasn't just a verbal warning that Ted Stryker was given. The area was actually blocked off. So he was given both a verbal warning and he was given a physical warning. The area was blocked off. And one man made a conscious decision to ignore the verbal warning, the plaintiff. One man made a conscious decision to ignore the physical warning, the plaintiff. No one else told him to do this. It was the plaintiff himself who chose to do this. It was the plaintiff's actions that are solely responsible for the happening of this accident. The owner didn't bang into the scaffold after ignoring the warnings. The general contractor didn't do that. The one person who did that is the one person who is now asking you for money. The plaintiff banged into it himself after ignoring the warnings. And that's why the accident happened. And that's why he's solely responsible for this. Ladies and gentlemen, I would be remiss, though, as a defense attorney, if I left it there to just say he's solely responsible. So I want to give you a broader understanding of the injuries also, and the damages. We do not concede for 1 second, though, while I speak to you about the damages, that we are in any way at fault. Fault rests solely with the plaintiff himself. Here's what happened. Yes, he was taken to the hospital. Yes, he suffered a subdural hematoma, and yes, he was hospitalized for 10 days. And I'm going to tell you something else. He made a 100% recovery from this, and there's no question about that either. Because when he left, the doctors provided him with something that you need to know about. He was provided with medications. This case boils down to a failure to accept responsibility for your own actions. Failure to accept responsibility for your own actions in not listening to the instructions, the warnings, the directions that you were given by coworkers when they say, don't come through. And then, when the doctors give him medications, and they say to him, here are the medications. Take your medications. So he goes and he gets a job as a cab driver. There is one man who didn't take his medications as ordered by the doctor. The same man that chose to disregard the warnings at the construction site. Once again, he didn't do exactly what he was told, and he suffered a seizure. Because of himself. So if you want to know what the case is all about, look back to him. And then you heard that he got a job as a doorman. It's true, he got a job as a doorman. And he says because of headaches, he can't perform his job duties. Is there one of us who hasn't had a headache and gone to work? He doesn't take his medications. And then he tries to blame us and says, pay me. Ladies and gentlemen, it goes further than that. Because he asked for one other job. He asked for a job as a security officer, a security guard. something you didn't hear about before. He applies for the job as a security guard. He doesn't get the job, not because of this accident, not because of anything that happened in April of 2009. He doesn't get the job because of one thing. 28 years earlier, he had done something as a young man. We're not saying this had anything to do with causing the accident. But 28 years ago, he was convicted of a felony for illegal sports betting. So when he applied for the job and they did a background check on him, he didn't get the job because of himself once again. So what you have here, ladies and gentlemen, to understand how this accident happened and why this accident happened, we say there's only one thing you need to do, and that is to tell Mr. Stryker, take a good hard look in the mirror, and he'll see exactly who's at fault for the happening of this accident. Ladies and gentlemen, we too will stand up here and ask you to award a verdict in favor of the defense. My co-counsel, Jeffrey Samuel, the man seated right next to me, will stand up here and he will ask you point blank at the end of this case to find what this case is all about, and that is that the sole reason, the only reason, the sole proximate cause, if I may borrow from what the judge is going to talk about later on, the sole proximate cause rests only with the plaintiff. And you will. All right, time for lunch. Come on.